Welcome to Wills and Trusts in 20. This tutorial is aimed at giving you the basic information about wills and trusts, the differences between the two of them, and how you might incorporate them into your estate plan. This is not going to make anybody an expert on any topic in estate planning. This is just to give you the basic information for you to start your estate planning journey. So first of all, wills and trusts. Why have either? There are 3 points I'd like to make. The first one is you will centralize your estate, meaning that you'll be creating one source from which all your debts and expenses will be paid, the cost to maintain your property during administration will be taken care of, and one source from which all the inheritance will be dispersed. Now that's important as opposed to relying solely on beneficiary designations, your PODs and your TODs. From which you will have several sources from which your debts will be paid and inheritances will be dispersed. Problem with that, the big one would be if you ever want to make an alteration in the future. You are not going to just one source, you're going to several different sources, all your banks, all your insurers, all your financial agents to make these changes. And that's going to be problematic for you, giving yourself a lot of work. It should be a priority to keep the number of changes you have to make to a minimum. With a will or a trust, you keep that to a minimum. And so if you ever feel like making a change, you just go to your will or your trust and you make the bulk of your changes right there. So the second reason is you will put the people you trust in charge of administering your estates. If you have a will, you'll be nominating who will be your personal representative. If you have a trust, you'll be nominating who will be your successor trustee. These are the folks who are going to step in and pay off your final expenses, pay off your final taxes, and distribute your estate in the manner you want it to be distributed. If you don't have those persons in place, those nominees in place, then somebody out there is going to nominate themselves. And whether that's somebody you want to be handling your administration or not, is out of your control. So if you want to have say in basically who's going to be cleaning up the estate, then you need to have a estate planning vehicle like a will or a trust to do so. The third point, why you need one or the other, this is a big one, is you can place protections on the inheritances that your family will receive. So you can draft your estate plan such that divorcing spouses, creditors, attorneys in lawsuits or bankruptcy courts cannot come after the inheritance you leave your beneficiaries. You can also ensure that if any beneficiary is either presently on SSI or Medicaid or may become enrolled in those programs in the future, that you would not necessarily be disrupting their benefits. And lastly, you can never be too sure if a beneficiary is in a good place to be inheriting at that time in their life. They may have developed an addiction problem or have some psychiatric issues that perhaps are not present now but could become present in the future. You can place protections in those plans to make sure that such persons would not just be receiving an inheritance with no strings attached. So the bottom line here when it comes to wills or trusts is you need one or the other. Very, very, very rarely would I say to somebody that you don't need either. You basically would have to be somebody who is fully expecting to pass away within the next 6 months. So we know what their life's going to be like for the foreseeable future, and we have a pretty good idea of where their beneficiaries are going to be at the time that they inherit. Absent that sort of near certainty, then we need to have plans in place that you can only get from a will or a trust. All right, so let's look at wills and trusts, starting with wills. So Wills 101. First of all, will-based plans are expected to send your estate through probate. Probate is the court process through which your estate is administered. It's the default for administering estates. So it's where your final debts and expenses are going to be paid, your final taxes are going to be paid, and your estate is properly divided amongst your beneficiaries. Here's what you need to know about probate is that it usually takes about a year in Wisconsin. Other states, a little bit less. Wisconsin's pretty typical for about a year. You can get it down a few months, down to maybe 10 months or so. It can go longer. It can go much longer than a year, but a year is about what you should be expecting. And the costs associated with probate tend to range in the 3 to 5% of the estate value. And those costs emerge from court costs, attorney's fees, other professional fees like CPAs, the costs associated with maintaining and selling property, and personal representatives fees. So it usually winds up in that 3 to 5% range of the estate value. Here's something very, very important to know. If you have minor children, you need a will, because a will is the only place where you can nominate guardians for your minor children. You cannot do it in a trust or any other legal document. So if you want to have a say in who's going to take care of your children if something were to happen to you, you absolutely need to have a will, at least as a component of your estate plan. Some odds and ends when it comes to wills. First of all, probate is a court process that is public. Anybody off the street can go walk into the probate court and say, hey, I want to take a look at that will that was filed. I want to take a look at the inventory that was filed so I know what the will be controlling in terms of assets. And so they would know exactly what's in your estate and to who it's going. Anybody has the ability to do that with a will-based plan. And if you have properties in multiple states, say you have your house up here in Wisconsin, but you have another property, a condo, another house down in Florida, Texas, or Arizona, or some other place, then you pass away with a will-based plan, there's going to be multiple probates for your family, most likely, multiple probates for your family. So they may not be full probate. There could be a full probate here in Wisconsin and what's called an ancillary probate in another state, but your family's still likely hiring 2 attorneys and is putting up more costs in order to get your estate administered if you have a will-based plan. Wills, the costs of wills in this area of the state, I'll give it a range of about $500 to $1,500. Now, the factors that can sway that up or down are you single or are you married? Are we planning for a married couple that's going to be cost more? Is this a first or second marriage? And is it a blended family? Meaning, did you bring in children from a previous relationship? Did your spouse bring children from a previous relationship? And are you going to plan differently? That can raise the price. The complexities of the inheritances, if something's going to be, really specific, that could end up costing more. The size of the estate, particularly if it's potentially taxable, which isn't very often anymore. But if you do have a taxable estate, the planning that goes involved in that is going to be pretty expensive. And the expertise of the drafting attorney. If you have an attorney that just does wills on the side, say when they're not in trial for DUI cases, which they specialize in, then it's not going to be that expensive. But if you have an attorney who handles estate planning exclusively or as a major part of their practice, they're going to have more knowledge of what can be done best within an estate plan, and those are going to be more costly. So who should get a will? Young families. You have minor children, you should get a will. Because otherwise, who's going to be caring for your children if something were to happen to you is out of your hands completely. Families on a tight budget. I told you the price for a will, that's usually half to a third the cost of a trust. So if upfront costs are a big concern for you, then a will-based plan would be, and technically that usually coincides with young families, usually on a tight budget. And families that would benefit from the estate being overseen by the probate court. So you have children who are not going to get along, or if there are going to be other issues, and you say, well, we need structure that a court's going to provide to make sure everybody plays nice, then a will-based plan would be perfectly suitable. Trusts. We're on to trusts now. Trusts 101. Now, the big question I often get is, what is a trust? It's not commonly known. Essentially, it's a legal entity that can own and control assets. One analogy that I use, think of it as a business, like an LLC or a corporation. Corporations and LLCs can own assets. They can own properties, they can own accounts, they can own insurance policies. The companies do. The people who work there don't own those. The companies do. So this is a business that doesn't really do any business. It's not out to make money. It's not out to provide a good or service. So it's a business that doesn't do any business. Now, a company, a business, will have a president or CEO to make the major decisions. A trust would have a trustee. If we're talking basic estate planning, then you would be your own trustee. So you would transfer your assets into the trust, or most of your assets into the trust, but still maintain full control over them. So you would not notice a difference in your life. Now, there are two types of trust. I already mentioned revocable. There's also irrevocable. Revocable are commonly used for basic estate planning as an alternative to wills. Irrevocable trusts are commonly used for asset protection, for tax planning, and for long-term care planning. When I put together irrevocable trusts, they are most commonly used for long-term care planning. But here we're focusing on the differences between wills and trusts, so I want to focus primarily on revocable trusts. So a key benefit of a revocable trust-based plan is you are avoiding probate. Instead of probate, your family goes through a process called trust administration, or trust settlement. It can be called either way. Usually takes half or less than half the time of probate, as opposed to a year. It could take less than 6 months, 5 months, perhaps even 4.5 months. And the costs on the back end are less too. Instead of 3 to 5%, you're looking at 2 to 3%. That may not seem like much, but even a 2% difference on, say, a $500,000 estate, that's $10,000 you are preserving for your family. So trust administration is a lot, it goes through the same beats as probate, but you're not doing it on the court's calendar. The probate court calendar could set things off for weeks or months at a time, as opposed to your family's going to be doing it on their own time. That's why it can be cleaned up a lot faster once all the creditors are notified and satisfied. Trust-based plans still come with wills. You have what's called pour-over wills, which would just make sure that everything works together. So if you leave something outside of your trust and then you pass away, this would be common for like a vehicle. The vehicle is not just left there to flounder. It's going to still work with your trust-based plan. Ideally, though, everything is already within the trust or controlled by the trust, so a pour-over will would not be necessary, but it's always there anyway. Odds and ends when it comes to a trust, they are private. Nobody has the right, other than your family and the beneficiaries of your trust, to find out what's going on with the trust. Somebody can't say, well, I want to take a look. Somebody off the street can't say, well, I want to know where all that money's going. They have no right to do that. Trusts are private, unlike will-based plans going through probate. If you have properties in multiple states, this is key, because you would still, assuming they are funded into the trust properly, have only one trust administration as opposed to multiple probates. So you're saving even more time and even more expenses. So if you have that extra property down south, trust-based plan is really going to be the way to go for you. The costs of a trust are more expensive up front, usually 2 to 3 times more expensive than a will-based plan. So whereas a will, I said $500 to $1,500, here we're looking at $1,500 to $4,500 typical in this area. The expenses are there because we're creating the structure within the trust that would normally be provided by the probate court. We want to avoid the probate court, but there's still a lot of structure we want to have. So we're building that into the trusts. That takes a lot of work. Further, I already showed you that the cost associated on the back end with trust administration can be significantly less than going through probate. So even though they're more expensive up front, there's a bigger savings on the back end most of the time with a trust-based plan. That's another reason why they are more costly up front. So who should get a trust, particularly, as I said, a revocable trust? If you don't have minor children, okay, not saying that if you have minor children you shouldn't get a trust. It'd be pretty rare for me to recommend that, though. For most families with minor children, I would say stick with a will. Not necessarily all the time, but if you don't have minor children, you never had children, or they're all grown up, they're out of the house. Time to start looking to convert your estate plan to a trust-based estate plan. If you want your heirs to avoid probate, if you have been through probate either as a personal representative or as somebody who is waiting for a probate to be settled, to be finalized, then you know how long and how much of a hassle they can be. If you want to save your family that cost and hassle, then looking into a trust would be this would be the time to do that. And if you can fit the larger upfront costs into your budget. So as I mentioned, will's going to work if you don't have the current capital to front the cost for a trust-based plan, a will would work. But if you have the funds, to make this investment, when it is an investment and it's going to save your family in the back end, if you have those available funds, then I often recommend a trust-based plan. So that'd be it for this presentation. For more information, visit my website at mclearlaw.com. You can follow me on Facebook, facebook.com/mclearlaw. And you can find this video as well as many, many, many other legal educational videos at my YouTube page. I don't have a fancy URL for that. I don't have enough followers for that. You need a couple hundred followers before you can do that. So just go to YouTube and search for McClear Law Office. Thank you very much for viewing this. Hope you got a lot out of it.